Hello, my name is Jessica Cameron. This is my week 7 research presentation. This is for business law. I was asked to complete a research presentation on a broad topic related to business law. I chose to focus on the Title 7 of the Civil Rights Act. The reason I chose this was because it has enough to support a research paper. There is evidence of this topic that is found in multiple cases. I have analyzed how businesses are impacted by the laws and court decisions related to my topic. And my presentation does have at least 15 slides, not including the reference slides, and it is going to be at least 6 minutes in length. I have my reference page on the very last page of the presentation, and this is my recorded narrative. And to begin, I will start with, again, this is the Title 7 of the Civil Rights Act. Again, my name is Jessica Cameron. Title 7 of the Civil Rights Act was created in 1964. It is a federal law that prohibits discrimination in employment on the basis of sex, race, color, and national origin and religion. It applies to employers that have 15 or more employees, including federal, state, and local governments. Private and public colleagues in universities, employment agencies, and labor organizations are also included. It is said that it shall be unlawful employment practice for an employer to for one, to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. Number 2, to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. Somewhat repetitive, but it's easy to understand that it's very important to not discriminate. There are discriminatory practices under Title 7. These include denial of employment opportunities to a person because of their marriage with an associate, their participation in schools or place of worship, the abilities, traits, or performance of individuals of a certain sex, race, age, religion, or ethnic groups. Again, sorry for the repetitiveness, but another discriminatory practice is harassment. And retaliation against an individual for filing a charge of discrimination is prohibited. The Equal Employment Opportunity Commission, if you have been subject to discrimination in violation of the Title 7, you generally have 180 days or 6 months from the date of the last incident to file a complaint. It's very important that you do this with the Equal Employment Opportunity Commission. Using internal procedures at your workplace does not extend the time limit set by the federal law, although under some states there are exceptions. EEOC, this is just an abbreviation for Equal Employment Opportunity Commission. If you feel you've been discriminated against, you have the right to file the charge. And even if you aren't ready to file, it's important that you contact the EEOC to speak with a counselor about your legal rights. You don't have to hire a lawyer, but you are able to do so. Title 7 passage was more than 50 years ago. Discrimination in the workplace remains a serious problem even today. If you have questions about discrimination in the workplace, or if you believe you have been faced with unlawful discrimination at work, this resource will help get you started, and that is in reference to the EEOC. There was a question that came up that I found interesting. What is the difference between the Equal Pay Act and the Title VII? Title VII prohibits practices are bordered than those covered by the Equal Pay Act. The EPA only prohibits pay discrimination based on sex. Title VII bars employment discrimination based on race, color, religion, national origin, as well as sex. For example, workplace harassment is covered under the Title VII, not the EPA. Another question, can my employer take action against me for filing discrimination charges or speaking up about a potential Title VII violation? No. That's the short answer, no, they cannot. Title VII forbids employers from retaliating against you for filing a charge of discrimination or speaking out against it in your workplace. It protects you from retaliation if you choose to participate in an investigation. Don't be afraid to speak up if you observe discrimination in your workplace. They cannot retaliate against you for speaking up. But before the Civil Rights Act of 1964, an employer could reject a job applicant because of his or her race, religion, sex, or national origin. An employer could turn down an employee for a promotion, decide not to give him or her a particular assignment, or in some other ways discriminate against the person because he or she was Black, white, Jewish, Muslim, Christian, a man or a woman, or Italian, German, Swedish. It would have been legal before the Civil Rights Act of 1964. That is why it is so important that we have this. When the Title VII of the Civil Rights Act was passed, employment discrimination was officially prohibited. Again, that includes what I've said before: race, religion, sex, national origin, and the color. That is all illegal to discriminate against. It protects the company's employees as usual. So how does the Title VI of the Civil Rights Act, Title VII of the Civil Rights Act in 1964 protect you? It prohibits the employees and job applicants from being discriminated against. Again, I have mentioned the EEOC. The employer cannot make hiring decisions based on the applicant's color, race, sex, or national origin. An employer can't discriminate based on these factors when recruiting job candidates, advertising for a job, or testing applicants. An employer can't decide whether or not to promote a worker or fire one based on the employee's color, race, religion, sex, or national origins. He or she can't use this information when classifying or assigning workers. An employer can't use what I have stated again to determine his or her pay, fringe benefits, retirement plans, or disability laws. An employer cannot harass you because of your race, color, religion, sex, or national origins. So that's 1964 for the Title VII. But in 1978, the Pregnancy Discrimination Act amended with the Title VII of the Civil Rights Act, made it illegal to discriminate against pregnant women in matters related to the employment. You're able to read about this online. Obviously, that's the Pregnancy Discrimination Act. I have included when the act was codified in Section 2000, July 2nd, 1964. It was signed into law. There's addition of number of titles in the act that prohibited discrimination in lodging, voter registration, and education. The Civil Rights Act also codified Title VII, which created rights for individuals to be free from discrimination in employment. For example, if you're in a school or college or university and they're failing to hire an individual based solely on their religion, this is discrimination. Obviously, they cannot choose to not hire somebody based on their religion only. Throughout my presentation, I have given you many different examples, and I know it has been repetitive, but the whole point of the Title VII Act is that there's no discrimination tolerated in this day and age. And I hope that you found this presentation educational. Thank you for listening.